Hello everybody, I'm George from Ireland, so welcome back to my English Law channel. So now I'm going to look at the Land Registration Act 2002 and interests that override, as we're now encouraged to call them. So the LRA 2002 made some changes to interests that override. It reduced the number of them, the ones that can bind, who are not recorded on the register. So if we look at section 70.1 of the LRA 1925, you see this has been replaced by something else. These new interests you'll find in Schedules 1 and 3 of the LRA 2002. So on the face of it, there's some similarity between the two schemes, but you have to be careful because there are distinctions. Schedule 1 is applicable to the registration of first title, and it's wider than Schedule 3, which is applicable to subsequent registrations and has a shorter list of interests that override. Now, why is there this distinction? That's because first registration is really administrative act. Actually, I think I've done some of this before, so I'll skip on a little bit. So we're looking to actual occupation, which makes a big difference. So this is trickier, these interests that override, if they need to be accompanied by actual occupation. Now, previously it was section 70.1G of the Act, which governed this, is now paragraph 2. So this part of the law is only about interest in land. So the fact that you occupy land is not in itself protected if the occupier doesn't have a separate interest in the property. It has to be occupation plus something else. But if the occupier does not have an interest there doesn't need to be any causal link between the interest and the occupation. For instance, there might be an unprotected option over the land by someone who coincidentally occupy the land by being a member of the family. Okay, and so this would still make it an interest that overrides. So it doesn't matter whether it's Schedule 1 or Schedule 3, the rights of the person in actual occupation are overriding only in as much as they coincide with occupation. If you look at Ferreshurst Limited against Wallside, 1998, it was underscored that actual occupation is really warning somebody who's thinking about buying it that their third-party rights might be extant. It doesn't actually guarantee that they are extant. It's a possibility. So actual occupation is different under Schedule 3, but not under Schedule 1, where the rights of the person in actual occupation will not override a purchaser in certain situations. Number one, inquiries have been made of the right holder, and the right holder did not declare these when they were reasonably expected to declare them. Or secondly, if the right holder's actual occupation is not easily detectable if you've made a fairly prudent inspection of the land, and the person potentially bound did not have actual knowledge of the interest at the time that the conveyance was made. So looking back to section 70.1G of the LPA 1925, we know it's been replaced by a different rule that seems to be easier on those who fail to declare their interest. A person can't declare a right if he didn't know about it. For instance, a sovereign might operate, but the interest holder, whose interest is proprietary under section 116 of the LRA 2002, would not know he has such a right, and so they can't disclose it if they're not aware of it. There's a new provision which has gone further, and perhaps unintentionally. It has overturned hyper-mortgage services against Robinson 1997. In this instance, it was held that a child, of course, cannot be expected to answer any question about interests. And someone who cannot be in occupation for the purpose of section 70.1G. Therefore, the court has restricted the provision only to when a purchaser can sensibly ask someone on the basis that it would be unfair to the purchaser if he's bound by this occupation of someone who couldn't answer the question about an interest because he was a child, otherwise lacked capacity. Now, this is different because the new provision says that only those who fail to answer the question when they could be reasonably expected to answer the question will lose their interests. Now, impliedly says that those who cannot answer the question could still be in occupation. Now, this doesn't excuse their failure to answer the question if, as per hypo-mortgage, they were not deemed to be in occupation as we would understand under this Act. So the LRA 2002 is more restrictive than the previous Act in another way, because it takes away overriding status from those who are in receipt of rents and profits in land. Right, there's another change which is more significant. and it is a major restriction. Interest holders in undiscoverable occupation are not protected anymore. So a buyer is not bound by this occupier's interest unless the interest holder's occupation, rather than their interest, is noticeable if you make a proper inspection of the land. So proper inspection just has to be reasonable. You can't look in every nook and cranny of a huge estate, but you can't just drive by at speed and not even walk through it. We have to figure out what is reasonable. Did you look at it properly with a fair degree of diligence? So anyway, the Law Commission suggested that the provision should not bring back the equitable doctrine of notice. So critics have said that it more or less is bringing it back, even if it's in a more discrete format. So constructive notice is what it's about. What's obvious, you see, they say that's contentious, and what's reasonably careful, that's an imponderable point. So there'll be many cases on this one, and so judges can't ever define it precisely. So it's too dubious. So some of the cases under the old law of section 70.1g are still pertinent if we're looking for an exegesis of the requirements pursuant to the LRA 2002. So still you have to be aware of these rules have changed somewhat, and say we're cautious when citing case law prior to 2003, because remember the LRA 2002 took effect in October 2003. Now, there's been much ink spilt in jurisprudential writings about actual occupation before 2002 and after. It's a bit of a watershed. The courts have, unsurprisingly, refused to give us a crystal clear definition or a test, that because so much depends on the nature of the land and the purpose of which the land is occupied. If you look at Link Lending against Buster 2002, decided by Lord Justice Mummery, or indeed Abbey National against Cann in 1990, was decided by Lord Oliver. So determining whether there's physical presence or not is a question of fact. That's what Lord Wilberforce said in Williams and Glyn's Bank against Boland, 1981, that seminal case about a spouse and occupation. So occupation will be more than something which is temporary or not be there for the sake of preparation, and it has to be some sort of continuity, something long term. Don't have to be there all day or every day. So usually this will be quite straightforward. If someone's living in a house, even the person's away the odd night, or goes on holiday once a year. But if the occupier's absence is for a long time, that might not even rule out the fact that it is an occupation. It depends how long they've occupied it for. If you've been occupied for 20 years and at some point you went away for 6 months, that might still be a proper occupation. If you've been there for 6 months, you go away for a further 6 months, that might not be proper still occupation. So, and the reason why the person was absent was unavoidable. Was there still an intention to continue to occupy? And this can be supported by keeping some of your personal effects there, particularly furniture. So we look at Link Lending, Choker and Choker, 1984, the case from Southall about this wife who's brought to India and abandoned there unconscionably, or Thompson against Foy, 2009. Look at AIB Group UK PLC against Turner, 2015. Right, another claimant could be an actual occupation using a representative, but not a licensee. Could be a caretaker, for instance. So Strand Securities against Caswell, 1965, that was the claim was there because the claimant's furniture was there. So exercising a right of way is a use of a servant land. It's not an occupation. That was decided in Chowdhury against Yavuz, 2011. If an easement is about parking or the right to store possessions, that might count for occupation under Section 2. Might enough to be overriding. And that might not be, trouble is that might not be blatant in a reasonably careful inspection of the land. So the date at which the claimant is said to be an actual occupation, when did that have to be in order to this to override disposition? That's difficult. Now this is problematic because a claimant moves into the occupation in the registration gap. That's the time that elapses between the date of completion is transferred to the disponee and the date when the title is actually registered. Days, usually weeks. So under Section 71G of the LRA 1925, the House of Lords in Abbey National against Cann said over to dicta that the date of transfer is the time for the test of actual occupation, all right? So not the date of registration. But the LRA 2002 says the person must be in a date in actual occupation at the date of the disposition. And this is taken to be the date of transfer. So there is a suggestion by some judges by like Lewison, for example, in Thompson and Foy, that occupation must continue until the time of registration. As I said earlier on, a beneficiary occupation can gain overriding status when the mortgage money is paid to just one trustee. That's, for example, in Boland, because that shows the dual nature of protection afforded by the LRA 2002. However, if the payment is to two trustees, then the beneficial rights cannot be overriding because they will already been overreached. Remember City of London Building Society against Flegg, 1988. So that's enough for this about registered land for the moment. Toodle pip.